And we'll turn it over to our speaker, Wes Hopper. Wes, this is the second time you've given a presentation on our series, so you're a very popular speaker and you picked a real good topic today. So tell us about tree owner rights and responsibilities.
All right, let me get my screen shared here. There it is. Can everyone see that? Here, share the screen, Wes. Now, can everyone see that?
There it is. Yes, we can see it.
Oh, awesome. Okay, I chose this topic because I think it's very interesting, and I run across a lot of situations. Well, let me back up just a minute. Let me explain to people who I am. I'm Wes Hopper. I'm the Natural Resource Manager and City Arborist for the city of Germantown, Tennessee. And I've worn many hats throughout my career. I've owned a tree service for 26 years, and I'm pushing to my 40th year in the industry. And somewhat become a resource for other arborists around the country because of my experience. And I'm actually writing an article on how I got to be where I'm at right now. And truthfully, it came from me being injured in the tree care industry. But I'll get into that some other time. I chose this topic because I do spend time in the courtroom and writing reports for attorneys in regards to tree owners' rights and responsibilities. For example, a lot of the cases that I work with is someone that trespasses onto someone else's property and they remove the trees that don't belong to them. Sometimes it's intentional and sometimes it's by mistake. Nonetheless, someone has to be responsible for that, for the replacement of those trees. And if anyone's read the Landscape Appraisals Guide, the 10th edition, you'll see where the replacement value is usually the best route to take as far as that goes, of being responsible for replacing those trees. I've also had to work a few cases where there's been death and injury because of a neglected vegetation. Generally, a tree falls into the roadway, and at the very moment a car's passing by and it lands on top of the vehicle, or it falls on a person's property, does $150,000 worth of damage. Someone has to be responsible for that. And I've also learned that these tree laws vary from state to state. For example, Tennessee has adopted the Hawaii rule, and we'll talk about that later in the presentation. I've worked a case in Mississippi where the tree owner does not have to be responsible for a hazardous tree in their yard. Like the tree could be dead, and the law says in northern Mississippi that the tree owner is not responsible for the care of their trees. Should it fall and land into someone else's landscape or into the right of way, then they consider that to be an act of God. Now, when it gets on commercial properties, the laws change a little bit. The commercial properties are responsible for the trees that are on their properties if it's going to affect the public or the right of ways. Arkansas is another state that does not have those laws. Everything falls under an act of God, but not in Tennessee and not in Virginia, and I think Kansas has adopted that rule also. So tree owners' rights and responsibility, whose tree is it, and an act of God versus negligence. I have 18 slides on this presentation, and that's what we're going to talk about. I really don't want to fill up everybody's brain cells with too much activity on this. And this information was first published by the UT Extension, University of Tennessee Extension Department. So I wanted to make that clear and make sure that they get the credit for this information. Okay. How do you know if this tree is yours? It is your tree if you or a previous landowner planted it and its main trunk is entirely within your property boundary. That's your tree, and you are responsible for the care of that tree here in Tennessee. Naturally occurring trees within a property are also generally the responsibility of the owner. That's important to know. And right now, the Mid-South, this year, the Mid-South had the worst storm it's the fourth largest storm that we had in the Mid-South history. And the way that is measured, it's measured by the number of power outages that we have. And so that's what rated it as the fourth largest storm, and it was an ice storm. What we're working on right now is updating the utility ordinance to read that the property owners are going to have to be responsible for the trees on their property. Right now, the utility ordinance does not read that. So we're working on with the committee to update that ordinance to read that the homeowners are responsible for those power outages. And what happened was, the reason we had so many power outages, it wasn't the trees that were within the easement of the utility department, the utility easement. Most of the trees fell from residential yards. Most of the trees that fell had defects, and they were obvious defects, but they were neglected. So we're trying to update that. Next slide. What if the tree grows on two properties? They're referred to as shared trees, either a boundary tree or borderline tree. Now this gets a little tricky right here. A boundary line tree is the property line passes through any part of its trunk. Yesterday I was talking to a gentleman who owns these very large trees here in Germantown, and one of the cable network companies were installing the cable line that runs to his yard, through the neighbor's yard, but he had a boundary line tree. He planted this tree many years ago. However, the flare of this tree had grown under the fence line and was attached to the other person's property. Well, this cable company had severed the roots on his side of the property, and he called the police. The gentleman I was talking to had called the police, and he told them if these people did not leave the property, then he wants them arrested for criminal trespassing. And he was within his rights for saying that. Was it going to kill the tree? We don't know. It hasn't been that long to determine that. However, it did make the tree unstable. And at this point, when the adjoining property owner has to manage what's on his side of the yard, even though the cable company could have installed the line somewhere else, should something happen to that tree, and the owner of that tree has to document this, send the letter to his attorney so that he can send the letter to that adjoining property owner, certified mail, so that he can acknowledge the fact that he was warned about this. Should that tree fall because those roots were cut, the person, that homeowner where he hired the contractor to cut those roots or install that cable line, he is responsible for any and all damages that come from that tree falling. Okay, we may talk about that a little bit further when we get to talk about some of these rules that we have. A borderline tree. A borderline tree is the tree's trunk is located entirely on one side of the property line, but the roots or branches extend over the line. Now here in Tennessee, and I'm sure it's in other states too, I just don't know all the rules in any other state. The property owner owns his property from ground to sky. And if those tree branches overhang his property and they're healthy branches, he has the right to protect his property by removing the limbs back to the property line. Should he cut back over to the other property line to make a proper cut, let's say if he cuts his limbs back to a stub cut to the property line, he's within his rights. But if he wants to make a proper cut and be ethical with this pruning, then he would have to have permission, written permission from his neighbor to climb that tree, or have his contractor climb that tree and make a proper collar cut. But you should not do that without written permission. We did have a case a few years back, probably about 3 years ago, where the property owner had to clean up his land. He just bought this beautiful $1 million piece of property, and it was a large corner piece of property. But for years it had overgrown. The trees had caused damage to the swimming pool that was there. The previous owner had just gotten old and unable to take care of the property. Well, he was removing trees on his own property, and he crossed the line a little bit, just barely, but just enough to remove the neighbor's trees. Okay, at the same time, the other neighbor on the other side had some hazard trees that needed to be removed. They were dead and leaning over the property. He got a verbal permission to remove the trees on that side. He said, ma'am, you mind if I take these trees down? They're half dead and I really don't want them falling on my property that I'm trying to put new landscape in. And she says, oh, sure, go right ahead. They need to be taken down anyway. Well, the other property owner, see, that was just a verbal commitment right there. Didn't get it in writing. The other neighbor where he did trespass it was no more than 14 inches that he trespassed. The property line was not defined. So he had to replace those trees that he had removed. And honestly, they were mostly privet, but it cost him about $8,000 to replace those trees. And that other property owner that owned the trees was so angry that he told all the other neighbors in the neighborhood what had happened. And on the other side of the property, where the lady gave him verbal permission, she jumped on the bandwagon and said, I didn't give you permission. I want you to replace all those trees that you cut down. Here he is again, same situation. He's out $16,000 in tree replacement because number one, he didn't have the proper property line marked, and nor did he have written permission. So that's the two cases when you're dealing with a boundary line tree or a borderline tree. Things to remember. I get asked by a lot of tree companies about this same situation, who's in the right and who's in the wrong. With this borderline tree, if let's say, for example, you wanted to remove the tree, you have to have written permission from both parties that own that tree, or the boundary line tree. I'm sorry, I said borderline tree. The borderline tree, they don't have to have written permission. However, to be a good neighbor, it would be good to communicate with the neighbor. Next slide. Again, a boundary tree is owned by both parties. Each owner has an interest in both boundary and borderline trees. That block tree law cases in the USA, that would be a case. If you wanted to look it up, you could read more about it. It's BLOCH if you want to write that down. According to Tennessee law, excuse me, can you prune the tree and roots over your own property line? Yes, you can. Again, I'll back up and say this again. According to Tennessee law, an adjoining landowner may prune away roots or vegetation intruding upon the property line at his or her own expense if roots or vegetation create a nuisance or cause harm or potential harm to the adjoining property. That's Lane versus W.J. Curry and Son. That's a very interesting case. That case happened here in Memphis. I don't know what part of Memphis, but it was, I think it was 2005, I think, where W.J. Curry owned this rental property, okay, and it was next door to the Lane property. And what had happened is, and this is how we adopted one of these rules that I want to talk about here in a minute. The Lane property, or Mrs. Lane, it was a Mrs. Lane owned her home, but she's on a fixed income, elderly, I'm going to assume, and W.J. Curry and Son were the property owners next door. Well, Miss Lane, the Curry property had a large branch from this oak tree fall through and went to her roof, and it was leaking. She couldn't afford to have the limb removed nor the roof repaired. So therefore it was causing damage to the inside of her house when it rained. Also, the tree's root system had grown into her plumbing, and she hadn't been able to use her plumbing or her toilet for 6 months. I don't know how she got by, but that's the story that on the case. Well, when she first went to the courts, they denied. The judge said this is a self-help situation, and self-help is described as if you want it fixed, you can do it yourself. It's pretty much that. So if you want to prune the roots back, that's up to you. Okay, so they denied her case against W.J. Curry and Son. Well, it got appealed. The Lane attorneys appealed this, and went back and she explained to him that I don't have the money to fix my roof. Mr. Curry or and son are not taking care of their property like they should. The grass is overgrown, the trees have dead wood in them, and it's just not working. I can't afford to work on his trees when they overhang my property and they're already presenting a hazard. And she said, well, the roots are growing into my plumbing. And when she told, in her case, her attorney stated that she hasn't been able to use her plumbing for over 6 months. The judge had a different heart about this. Anyway, it was the Supreme Court, and time went on, and eventually the state adopted the rules set up in Hawaii. And here in a minute, I will talk more about that. That's a particular case that you would find interesting if you were to read it. And also, I hope this will encourage everyone listening to this presentation to look into your state laws that regard the vegetation of adjoining property owners and yourself. Do you need consent from the adjoining property owner? Answer to that is no. If it's healthy foliage that you want to remove to protect your roof and your property, you have that right to protect your property and remove those trees from ground to sky, the branches. However, if the tree is a nuisance, dying or dead, obviously you have a defect on it, then you can contact your attorneys and make sure that you have the right documentation. What if the other property owner does not ask for consent or offer acknowledgement? Consent, again, is not required. However, if the other property owner maliciously cuts or destroys a boundary tree or borderline tree, then that property owner will be held liable for the damage. Cathcart versus Malone. Another interesting case. I read it, but I don't think you guys want to read it. But if you want to write that down, I'm sure you could find the information that you need. Can you remove a boundary or borderline tree? I mentioned this earlier. You have to have written permission from both parties. Both parties have a vested interest in that tree or vegetation. The tree belongs to both properties. Neither owner can remove the tree without the other owner's written consent and cannot cut away the part that extends onto his or her land if injury would result in harm to the common property of the tree. I had a case back in a different city in Lakeland, Tennessee, where this one property owner owned a pecan tree. And it was really a tree in the wrong spot. Beautiful tree, but they were not quite zero lot lines, but they were close enough to be zero lot lines. It was on a golf course. But the property owner that I was called out, is actually another tree company that called me out to investigate this and say, why can't we take this tree down? It's going to cause damage. It drops fruit. And I was like, well, she owns the tree and you own a portion of the root system. So you have the right to remove the root systems that's affecting you. Okay, so the arborist dug down and he found that there was probably a 10-inch root that was growing under the foundation of the home, of the property owner that had contacted me to investigate. So they were within their right protecting their property by removing that root. And they did not have to ask for permission. Funny thing about that is, though, the lady ended up moving out that owned the tree, and the next property owner that bought the property cut the tree down. Again, consent is not required, but should be obtained. What if my arborist can only perform the routine pruning on my side, but has to access the tree from the neighbor's yard? You must get consent from the neighbor, otherwise it will be considered trespassing. My first experience with me being a tree climber back in my early day was I was told by my boss to climb this tree and remove the dead branches that were in it. I'm just a young kid. I didn't know any better. But as I was up in the tree, the man came out with a gun and said he was going to shoot me if I didn't get out of his tree. It sounds funny, but at the time it wasn't. But that was the case. I was actually trespassing on a property that didn't belong to my client or that I was working for. And you can get permission though. Usually it's not a difficult situation, you know, to be in when you get written permission from somebody, and everybody benefits. The tree gets pruned properly by a professional, and you know, it's usually not an issue. For example, one of the employees that works here in Germantown, we were talking about this yesterday. He has this large tree. I don't know if it's the same large tree where he had the roots cut by the cable company or not, but his branches from his tree overhang his neighbor's tree. His neighbor got written permission from him to prune the trees back, and he was perfectly happy with it. The tree was fine. It didn't look bad. But the man wanted to protect his tree because he has grandchildren that play back there. He didn't want a branch falling. What is self-help? Self-help, you know, I mentioned this a little bit earlier. It's when you take the initiative to do things yourself. Like my neighbor took it upon his or herself to hire a contractor to remove the hazardous dead branches that were overhanging their property. The contractor did not have access to my property. So self-help, they would hire a contractor with an aerial lift from his property and go up and remove the branches. If those hazardous or dead branches that are up there that need to be removed, I would say that if the contractor got written permission to climb that tree, he would be well within his rights. Sometimes self-help is not necessarily the answer. Sometimes you need to involve the other neighbors so that everybody's understanding what's going on. I had another case where permission was not asked, and at the time I didn't understand all the rules, and after I seen what happened, I didn't want to be involved any further. I just felt like it was going to be a nightmare, and it really turned out to be. This contractor was demoing a old building in Midtown Memphis, and as doing so, he destroyed the entire one half of the root system, probably more like 3/4 of it, and he left the remaining portion of the tree overhanging this neighbor that had contacted me to look at the tree. My advice was to have the tree removed and contact his attorneys and make that contractor responsible for that. But that's a situation that could really, really turn bad. I opted to step out of that one. I didn't want to be involved with it anymore. And you don't have to take on every case. What if my neighboring property is a rental and dead branches keep falling in my patio area? Again, Lane versus Curry and Sons, same rules. The adjacent rental has 3 large trees that have put holes in the plaintiff's roof and the roots have clogged her sewer pipes. That's the case that I was talking about earlier. The trees were considered a nuisance and the extent of damage was assessed, and the trees were now considered a nuisance. And I'm getting to the rules that apply to that word nuisance specifically. These rules, the adopted rules, the Virginia rule and the Hawaii rule. Okay. The old Virginia rule set out in Smith versus Holt has said that a landowner can sue his neighbor only if the plant that was sending its roots or branches across the boundary line was a noxious plant. The court in Fancher couldn't figure out whether a sweet gum tree with evading roots was noxious and didn't think it was a valid basis for decision. So can the neighbor sue his other neighbor? Answer, maybe, but you probably won't win. Accordingly, we now overrule Smith versus Holt insofar as its conditions a right of action upon the noxious nature of a plant that sends forth invading roots or branches into a neighbor's property. We find the reasoning of the Tennessee court in Lane versus Curry and Sons persuasive and adopt the Hawaii approach as expressed in that case. The Hawaii rule states that if the tree is a nuisance or has an obvious defect that's going to cause damage to the property next door, then the owner of that tree is responsible for any and all damages to person or property. We had a case, it really wasn't a case, but I had a client in Midtown Memphis that just bought the property. He moved down from Pennsylvania and he wanted to be a good neighbor. So he took care of his trees. He hired my company several times to work on the trees. But the neighbor next door, it was a rental property, had this huge oak tree and it was in decline. It had the Ganoderma fungus growing all around the base, the Ganoderma and the Inonotus tradeus fungus all around the base of the tree. And you could see the bark coming off, but the tree was still living. I said, do you want me to write a letter for you to send to your attorney? And because this tree is obviously being neglected and it should be removed. I mean, you're really in a bad situation. And he said, no. He said, I just want to be a good neighbor. I don't want to stir up any trouble. And I said, are you sure? I'll write this letter for you and it'll work. Well, he refused. And about 4 or 5 months later, this 5-foot diameter tree, 110 foot tall, fell on his house, and not only on his house, but the adjoining property's owner's house. It cost over $150,000 worth of damage. Had he written that letter to his and sent it to his attorney, or had me write the letter and he sent it to his attorney sent it certified mail to that owner, then he had a case. He could have proved that that tree was hazard prior to it falling, and that person's homeowner's insurance would have been responsible for repairing all those damages. The bad thing about this happening is their insurance company had to pay for all that. And they also had to move out of their home for over 6 months. That cost them additional dollars. So understanding your rights and responsibilities to me is very important. When is a tree considered to be a nuisance? As arborists, we can see a damaged tree, we can see decay, we can identify those things. Homeowners can't always do that. Therefore, they should have someone that they could depend on that could come out and do an annual, biannual tree inspection. A tree is considered to be a public nuisance or an act of negligence when the litter it creates has the potential to cause harm or pose imminent danger. Example, a dead or dying tree, split or broken branches, connections, obvious severe root decay, and overhanging large dead limbs. Now, I do a lot of consulting with the public. And when I visit a property and I'm looking up, I don't ride the fence on anything. I make good, strong, firm decisions. If I see these examples, the dead or dying, split branches, severe root decay, I write it down and I give my advice. If they follow the advice, fine. If they don't, it's on them. But as a good professional arborist, I'm just going to state the facts. You go into a courtroom, you state the facts. Landowner's tree rights. A landowner's tree rights limit nuisance claims and trespass regarding cutting, trimming, or removing trees that extend beyond property boundaries, especially abutting easements for streets and utilities. Streets and utility easements are a little bit different. When the trees grow into those easements, there's ordinances that state that your tree has to be 13 feet 6 inches above the street for the emergency vehicles such as the fire trucks. Utility line easements, they have the right to prune any tree that's within single line phase, that would be 10 feet, double phase, and triple phase 13 feet. I don't know how it is in other states, but that's the rules here. They have that easement and they will prune back to that point, not any further. If the utility company is pruning back beyond that 10 feet or that 13 feet, then they would be falling under that trespassing rule. So the question gets asked a lot, why don't the utility companies prune back to the branch collar properly? Well, that's because of what I just said. It's the trespassing rules. Hopefully after our committee updates our utility ordinance, maybe we can change some of that a little bit. What happens when someone maliciously trespasses and damages my tree? I've got a case right now that I'm working on. We'll have the deposition next week, and it was a crazy situation. One neighbor talked to the neighbor, my client, called him up on the phone and said, you know, we're going to do a little pruning on your tree. And he said, okay, but just, you know, don't mess it up. Well, my client travels down to Florida, and while they're gone, they cuts down not one, but 1, 2, 4 of his trees that were in his yard that were strategically planted. They had grown to the point to where one of them was a boundary tree, but because he had the opportunity to cut the trees down, then he just took advantage of it and was willing to pay the price to do so. I had another case, and this may or may not make you laugh, but it sure made me laugh. I had a lady, she called me and told me that while she was at work, her neighbor hired a contractor, pretty much it was just a guy off the street, and cut down every single tree in her front yard. Japanese maples, a 13-inch diameter Japanese maple, all her crepe myrtles, every single tree in her front yard. And said he would have cut down the trees in her backyard, but the gate was locked. And while I was talking to my client, I felt so sorry for her, I didn't even charge her. But as I was talking to my client, and she was so frantic telling me the story and how angry she was, I made a joke to her. I said, it sounds like you punched this neighbor. She says, who told you? I said, did you really hit her? She said, yeah, I hit her so hard I knocked her wig off. But the lady had a connection with the police department, and her neighbor was arrested and put in jail because it was over $500 worth of damage, and that changed it from a misdemeanor to a felony. I've seen other cases where, of course, they had to be out of town. This one neighbor had a swimming pool, and the other neighbor had gum trees that were probably 100 foot tall. And while that neighbor was out of town, they hired a contractor to come in and topped out every single tree in his yard, just cut the tops right out of them, cut them halfway down, and left a pole standing. I don't know what came of that case. But Jones versus Johnson, according to the trespass law in Tennessee, others are not allowed to harm a landowner's tree. Jones versus Johnson, 2002. Johnson trespassed onto Jones' property and made several deep chainsaw cuts into a large black walnut. Jones had to pay to have it cut down, and the courts awarded Jones 5 times the amount he paid to have it removed. As y'all know, a black walnut has some extreme value. I had a case with black walnut trees probably about 10 or 15 years ago, where a renter had rented this small cabin from my client, and they were black walnut trees, and these black walnuts that the nuts were harvested, so they were treated as a crop. But the renter took it upon themselves to cut the trees down, hired the neighbor and cut the trees down and used it for firewood. Well, it made it to the courts, and I'm in the courtroom stating my case. I used the 9th edition to come up with the value. I had to explain to the judge and the opposing attorney step by step how I came up with the numbers. And those of you that have used the either edition, the 9th edition or the 10th edition, to come up with the value of a tree, then you know the process. If you haven't, take the moment to look into that and just see what it takes to come up with the value. It may help your clients a lot to understand what they have in their yard. By the way, my client lost. And the bill became so high that my client really couldn't afford it. So the remaining portion of the bill that they owed me, I donated it to their Christmas. They were treating their mother for Alzheimer's, and it was just a mess. They were in a bad situation, so I just gave them their money back. An act of God. This is a good one because a lot of cases the trees that fall are considered an act of God. When the several times that I've been asked to about a tree, I get asked this one question every single time. Could a layperson tell if this tree was a hazard prior to it falling? It's very easy. It's a yes or a no question. I do my investigation, and sometimes it's a yes, other times it's a no. We had a case in Mississippi where a tree had fallen and taken the lives of 2 people. They were in a camping trailer. And that was the one question that I was asked. Could the layperson tell if that tree was failing prior to them, prior to the tree falling? Obviously, if this person could tell if this tree was a hazard or not, I don't think they would have parked their camping trailer right there. So my answer was no. Did my client win? Yes. An act of God is an inevitable accident that could not have been prevented by human care, skill, or foresight, but which results exclusively from nature's cause, such as lightning, storms, or floods. In this case, the landowners are not liable. But it is not an act of God if it could have been prevented by reasonable diligence or ordinary care. So if you live within the canopy, if we have trees in our yard, or your client or neighbor has trees in the yard, then we or them are living in a situation where we're willing to accept a reasonable amount of risk. However, if you're leaving large dead branches in the tree, or you know that the tree has a big hole in it, like a pecan tree that has a big cavity in it midway up, then you're not showing due diligence or taking ordinary care to be responsible for that tree. I've had to do it in my own yard. Right now, I think I have 15 different species in my yard and about 25 trees planted in my yard. Big and small, one big one, the rest are small, but that's the way I wanted it. But I can assure you that I've cut down that many trees over the last 30 years I've lived in this house. So I've cut and replaced, but I got to the point to where in my yard, I have trees that are manageable. They're small enough to provide shade, but they're not so much that it's going to cost me a lot of money. I had planted years ago, I planted a weeping willow in my yard. I planted it for my wife. That's what she wanted, so that's what she got. I knew the trees, and I explained to her that eventually these 2 trees that I have, they're going to get a nectary canker of some sort, and they're going to die, and I'm going to have to remove them. Well, that was the case. One died, I removed it, and the other one, the upper canopy started to die back, and I had to make a choice. I could remove that dead upper canopy and hang on to the tree a little bit longer, but knowing that the tree was going to continue to die back like that, I made the decision to remove the tree, and me owning a tree company had to pay to have my own tree removed with a crane reaching over the house and all that. So I had to show due diligence in my own yard to protect my family and my house and those that visited my property. So due diligence or ordinary care, just be responsible. We're excited. The Tennessee statutes, the Tennessee Code 39-14-405 and Tennessee Judicial Opinions, Cartwright versus Malone. What is the most contentious trespass? Okay, you wouldn't believe how many people trespass. I mean, it's kind of crazy, and we have to think about that when and be conscious of that when we're working on a property. My most recent case, I don't want to get too far into it, but I had to evaluate some trees that my client had. I don't know if he accidentally took them down or if he did it on purpose. Personally, I think he just didn't mark his property line properly, and he took the trees down. But I had to stand on the one side of the property and not trespass to look at the rest of the property to see to determine what trees he had cut down. So I had to be conscious of not trespassing, even though that person could not have seen me trespassing. It was a wooded area. I wasn't going to do it. Tree trimming or right-of-way maintenance by utilities or municipalities. Determine if the company has authority to trim. Determine if there's an easement on your property. The easement holder has the right to remove any obstruction that threatens the use of the easement. The authority of the utility to use the street does not empower or authorize it to damage the trees or appropriate the land without compensation. Here in the Shelby County area, our utility company will remove the trees off the property owner's property, even if it's not within the easement, but it has to be within 10 feet of the utility wires. They'll remove that tree at no cost to the property owner and also replace it with a tree selection or tree species that does not grow back up into the utilities. That's about as fair as you can get right there. I've been a mediator for our power company for many years to stand between the utility company and my client and trying my best to explain that utility pruning is a requirement. It's a case of when you have utilities or you have trees. It's not a trade-off. Utility company is going to win. And when I talk about utility pruning or the other types of pruning, I ask a question. Do you know when the first power outage happened? The very first power outage happened in Syracuse, New York, I believe it was. It was the first week that the very first power line was installed. A branch fell and took out the power. I think it was Thomas Edison, the Rockefellers, and all those guys up in New York. And they were having this big celebration. They got their first street lights. Oh, yay. But that night, storm comes through, takes out the power line. So that was the beginning of the first utility pruning company. Uh-oh, my slide's not moving. Well, my screen stopped. Well, let's try this.
All right, Wes, well, let us work on that technicality there. I know Lisa's trying to fix that.
Okay.
Wes, do you want to stop sharing your screen and then reshare it? I don't know if it's frozen or what's happening.
Yeah. Should be frozen.
We can see it. Is it still not advancing though?
Uh-uh. Here we go. Going backwards. That one might be in the wrong spot, so that might be the end of the slide. Like I said, this was the first time I made this presentation. Litter, let's talk about this. A tree is not considered to be a nuisance if with it just dropping fruit or leaves or small sticks like that. That's not considered to be a nuisance. However, if it's dropping large dead branches, then it is. Well, in that case, do we want to drop over to some questions?
Yeah, we can take some questions. There's quite a few in the chat, and then I'll read these out. And folks, if you want to ask your own question, feel free to unmute yourself and ask away. First one, how do I get an expert opinion on damage caused on my tree by a neighbor?
What type of damage will we be talking about?
Well, they didn't say.
Okay. How would you go? In most cases, you take pictures. You always take pictures, have documentation, and I would hire a professional certified arborist with the credentials of risk assessment to take a look at the tree and document and determine what type of damage it was and what procedure. Is it the type of damage that would require some strong mitigation, or would it require just some moderate to light managing? Start with hiring a professional arborist.
Okay. Here's another one. Are you liable if your pruning of the roots causes the death of a tree on a neighbor's property?
If it can be proven, yes. Determine if the tree should be removed. First, always look for a reason to have to remove the tree. When I evaluate a tree, that's what I do. Strike one, strike two, strike three, you're out. Just like in baseball. I don't try to look for any other defects more than that because it's really not a waste of time, but three's enough. I look for the root rot. Is that the reason why the tree should be removed? Does it have enough defects in the tree where you could just have the tree slated for removal? If you cut the tree's roots though, and it causes the tree to die, then yes, you could be liable for the responsibility of removing that tree.
Okay. Let's see, I just lost one.
Can I elaborate a little bit more on that? Have it written, have a report written from a certified arborist that's qualified to write the report that those roots are causing structural damage to their property, or is it causing a trip hazard to that property? Is the property owner in a wheelchair or crutches or disabled of some sort? I've seen that before where I was like, you're going to have to cut these roots. You're not left with a choice. You have to protect your property and have that in writing. Okay.
Okay, here's a question about another one about roots. Roots in a sewer pipe. Do you have to prove that the roots broke the pipe?
Yes, but you can. This may fall under some. This could strongly fall under the self-help. I recently experienced this where and this is on my own property, where the tree did damage my plumbing and I had to have it repaired. That's self-help. If my neighbor's tree grew over and was damaging my roots, then I have the right to cut those roots to prevent them from getting back into my plumbing system. So that could fall under self-help. But if you want to cut them back to the property line, then you're pushing the boundaries. Even though you own those roots, they're growing onto your property, you just don't want to be that person who maliciously cuts the roots all the way back to the property line and the tree does end up dying.
Okay, we have a follow-up question to that. Jennifer asks, what about time? The tree roots were cut, but the damage may not show up for a few years.
That's true. I have a rule of thumb that you have like a 5-year period where if you have construction damage or you have severe root pruning damage, you got like a 5-year window, a 3 to 5 year window where the damage will show up later. It's kind of like on a construction site. An arborist can tell when a tree is falling into decline. And you'll see it over a 3 to 5 year period. And I think I've seen a chat where Marty had mentioned it depends on how old the pipe systems are.
Okay, I think there's one more in the chat, and then if anyone else has one, feel free to ask away. Any thoughts on chemical trespass, spraying herbicides along a property line to kill brush, small trees, etc.?
Yes, I had a case like that several years back where my client was really the obnoxious one, okay? I was hired by my attorney as a friend, an attorney friend that asked me to be on her case. The neighbor had planted some variegated privet along his property line, and as it was growing, it did encroach over barely onto my client's property, and our client ended up taking Roundup and spraying and killing all the hedges, and it was about 150 feet of hedges. That was a very expensive damage. He sprayed his side, and he ended up losing. He ended up losing the case. But yeah, chemical trespassing is the same. Here's a question. What's protocol for a dangerous tree on private property that threatens public safety? Here in Tennessee, that tree owner is responsible for any and all damages that should that tree fall and cause property damage or personal damage. Here in Germantown, we have code enforcement, and all cities have code enforcement. So that's a start right there too. You don't always have to hire an arborist. You can just call your code enforcement, send an address, and have it reported, and let code handle it from that point. We had a case in Memphis where my client, who was handicapped, she was bound to a wheelchair. Not that that matters or anything, but she has a particular way that she has to live her life. That should this tree fall on her property, she's kind of homebound. She can't take her normal route out to go down her ramp and get to her driveway or anything. And the adjoining property owner took her tree that was in her yard. It was a border tree, a borderline tree, not a boundary tree, but this tree had branches grew over into the neighboring property. And that property owner shaved this tree completely off, and the rest of the tree just loomed over my client's home. Instead of having a balanced canopy, everything just like leaned right over her property and where she sat in her dining room and everything. She wasn't comfortable, so she contacted code enforcement. She hired code enforcement, and code enforcement called me out to look at the tree, and I wrote her a letter stating just what I mentioned earlier, that property owner had pruned the tree to the point where it posed a hazard or risk, a moderate risk factor to my client.
Wes, we actually just got kind of a flurry of questions in the chat, and I know it's almost 1. I don't know if you maybe want to provide your email address in the chat for folks if they have questions afterwards, but I'm going to ask a couple really quickly.
Okay.
Let's see. What's protocol for a dangerous tree on, no, I'm sorry, that one we just read. What about tree sap fallen on a car, which is where the normal parking space is?
That's just, that doesn't fall under the noxious category. The tree is not a nuisance if it just drops fruit or leaves or twigs and things like that, and the sap which is usually the honeydew from the aphids or scale insect that's dripping off of it. So control the insect, and then you'll probably fix your problem. But no, that's nature.
Okay. Is there a soil treatment or something that can be done to slow the root growth on your side of the property?
You can use a growth regulator. Some growth regulators are meant to slow down the growth of the whole tree, and others are meant to slow down the canopy growth like the utility companies use. Or during construction, there's growth regulators that encourage root growth, but slows down the upper canopy. So yeah.
Do you have a form available to download to get adjoining property owners to sign when you need written permission to access their property for pruning or removal of the boundary property line trees?
I do not have a form for that. I usually just have something typed up and have two witnesses, you know, and get the signature. And don't make copies of it. You just use the original if it turns into a situation.
Okay, last one. Let's see. What if your local utility company is shaving trees away from the utility lines and it changes the weight headed towards the residents? Who is responsible then?
That's the case where determine if it did make the tree a hazard. The utility company should be responsible for that tree, but determine if it's truly a hazard or if it's just an eyesore. But the utility company, if that tree is within their easement, then the utility company is responsible. Yes.
Okay, thank you very much, Neil. I don't know if you want to hop on and talk about next month's webinar.
Yeah, and just to add another few seconds here, I wanted to reinforce something that Wes said at the very beginning, especially since we have so many people from all across the country, different states, and even people throughout the world watching this, that not every state is the same in how they view some of these issues. There are a lot of commonalities, but court cases and state statutes vary from state to state. And I just think, Wes, it's important for anyone here wanting to learn more about tree owner rights and responsibilities that they need to do some research where they live and see what laws and ordinances apply there. And one source might be just to, if there's a city attorney or if your organization has a lawyer, or even if you have a personal lawyer, they might be able to help you dig out and find out these variations and nuances where you live.
Neil, I have found that most attorneys don't know anything about trees and the law. It's up to the professional arborist to convey the proper information. Very rarely have I worked with an attorney that knew about trees and the law.
Okay, well, that comes from experience. Thank you for that. All right, let me exit the full screen here. And Lisa, if you can show the next slide, I want to do a little promo here for next month on what I think is a real interesting topic, green spaces and childhood development. Got to say that this is a new and exciting development in urban and community forestry as far as the benefits of trees and green spaces in our communities. There are a lot of research has come out that shows a very clear connection between public health and green spaces and urban forests, and especially to the vulnerable group of citizens, the child and the children that live in our cities, who suffer probably the most from bad air, lack of exercise, and other noises and distractions that hamper their development into adulthood. So anyway, we've got a great presentation next month from Ashley Kite Rowland. This is a passion of hers, and she's going to lay out some of the findings and the discoveries that have been made of how important it is to continue what we do in promoting trees in our communities as far as childhood development is concerned. So you don't want to miss that one. All right, with that, I want to thank Wes again for an outstanding presentation. You scratched the surface very well, Wes, and generate a lot of interest. And we may need to come back to this topic later in the future, but thank you, Wes.
Thank you.
All right, and everybody else, I have a good day.